That's fine.
Okay.
You mean where it says in my note, pause for recording?
He skipped right over that part.
Totally skipped over that. Thank you for joining us for today's webinar on the upcoming changes to paid family medical leave. We're joined today by Matt Cianflone and by Christina Marquez. Matt is general counsel for Gold Medal Bakery, having started in that position in January of 2023. He was previously a litigation partner at a law firm in Braintree. Matt is a graduate of Catholic University, where he earned a BA magna cum laude in politics, a dark art to say the least. He has a master's degree from the University of Pittsburgh in public and international affairs and earned his law degree from Duquesne University, cum laude. Additionally, he has completed postgraduate work at the London School of Economics. And for the last 13 years, he's focused on litigation and trial work, including representing individuals and corporations throughout New England and the Mid-Atlantic. Christina graduated from Rhode Island College in 2008 with a bachelor's degree in management and a concentration in human resources. She started at Gold Medal Bakery in April 2013 as HR representative and has held the responsibility for being the company's leave administrator since October 2013, taking care of all leave requests from employees working throughout 7 states in the New England area. She graduated from Salve Regina University's MBA program in May 2017 and has held her SHRM-CP certification since January 2018. She was promoted to her most current position at Gold Medal Bakery, HR manager, in April 2018, where she continues to learn and grow in her role. With that, I'll turn it over to Matt and Christina. Thank you.
Thanks, Rick, and thanks everyone at the Chamber. It's a privilege to be here today. I'll start off with a cliche where they say the best way to learn a subject is to write about it or to try to teach it. I can say that's absolutely true with respect to PFML. I thought I knew what the law was and how it applied and what the updates were. And then I actually started to read and go through it and realized how much I didn't know. So thank you for that. I needed to come up to this come up to speed, and this has helped me tremendously. So we'll start off with a little bit of basic information, as I'm sure most of the attendees today understand. PFML, Paid Family Medical Leave. It's a program designed to help people in the Commonwealth take paid time off for very specific reasons, family issues and medical reasons. Under PFML, most Massachusetts employees are entitled to at least partial wage replacement and job protection. So basically, you get paid while you're out, and when you come back, your job's waiting for you. It's funded through employee and employer contributions. So think of this akin to Social Security. I'm sure, again, as everybody's aware, the employer is paying something, the employees are paying something into it. That money is then put into a fund. You have, from an employer standpoint, you have the choice to have it either be operated by the Commonwealth, or you can go with a private plan. But those funds are put aside, and then you can tap into them in the event your employees need to take a leave for one of the predetermined reasons. About 26 weeks of leave combined are allowed in any given year. For our purposes today, we're going to talk about some recent updates. There are 2 of them. Christina is going to address what's called the top off, where employees can now, instead of getting partial wage reimbursement, they can get up to approximately, and I'll let her describe in detail, 100% for their leave by using their accrued sick time. And I'm going to cover very briefly some increases in what the employers and the employees have to contribute. And then I'll finish off with an issue that's been plaguing most employers with respect to the PFML rule about terminations and a 6-month window, and whether or not employers are in a quite vulnerable position if they do terminate somebody who's back from leave. So again, thanks so much. And I'm going to turn this over to Christina, and we'll get going.
Hi, good afternoon, everyone. So beginning November 1st, 2023, all employees now have the option to top off their PFML wage replacement benefits with their available accrued paid time off. Topping off allows employees on PFML to supplement their weekly PFML benefit with their accrued PTO up to their individual average weekly wage. So what does this mean? So prior to November 1st, only employers that offered PFML through a private plan had the option to allow their employees to top off their private plan benefits with the accrued paid time leave. And employees who were receiving PFML benefits through the public plan were not able to do this. The only benefit they received was they could use accrued paid time off during the 7-day waiting period when no PFML benefits were available to the employee. So now employees have the option now to use their accrued paid time off to top off their PFML benefit or save their paid time off for when they return to work. It's up to them, but employers must provide employees with this option. The top off amount that employers would need to pay out to employees who request it would be the difference between their individual average weekly wage and their approved PFML benefit amount. So how does this work? So both the individual average weekly wage and the PFML benefit amount will be provided to us on the notice of approval. That notice of approval can be found located within the employer's application website. As a leave administrator, we would have to subtract the PFML benefit amount from the individual average weekly wage and then divide the difference by that employee's hourly wage to calculate how much PTO they would be using each week. So I have an example for you. This is a sample of a notice of approval. So in here, we could see that the employee is eligible for $882.25 per week, and their average weekly wage is $1,234.90. So using those numbers in the calculation, we would subtract the PFML benefit from their average weekly wage amount, and that gives this employee $352.65 a week max top off. So that's what they can use to top off. For this example, I just said that the employee makes $30 an hour. So we would divide that by $30, and we can tell the employee that they would be using 11.75 hours of PTO per week if they decided to take the full 100% of their amount. I did include a calculator for you. This could be helpful now that the top off is in effect. This is located on the mass.gov website, and the URL below provides employees with an estimate of what their approved PFML benefit will be. We can use this also as leave administrators to help employees understand what they'll be receiving each week, so that way they can decide if they want to get the top off. All right, so I think that's all I have for you. I'm going to pass it back to Matt.
Thanks, Christina. So we're still figuring out here at Gold Medal how this is actually going to work in practice. Obviously, the change, as Christina explained, came through in the beginning of November. To date, we have not had an employee who has requested a top off. So the way that we're approaching this is, we understand the calculations as Christina worked through with everyone. We know what's coming if they request it. We can do those calculations. We have the resources through the mass.gov website. And we also understand it's on us to make sure that the employees know this is an option available to them if they want it. Ultimately, what everybody needs to remember, it's the employee's decision. We really shouldn't weigh in on what they should and shouldn't do. It's their choice. And there are pros and cons to it. On the one hand, if you have a person on leave, self-explanatory, they get more in their weekly pay if they decide to top off. The downstream effect, obviously, if they do this, is when they return from their protected leave, they could be out of accrued sick time, and that could create other problems for them if they need some additional time off in the future. And they're out of either they're out of available time through work, or they can't apply for any additional weeks. So we don't really know how this is going to work 100% in practice. But, again, to date in the last 6 weeks, no one has requested that top off yet. So we'll just have to deal with it as it comes. Obviously, what concerns us is if you have new employees that go out on the leave, they burn through all their sick time, and then they end up leaving anyway. That is a risk. It is one of the unintended consequences to this. But again, like I said, we'll just have to deal with it as it comes. So what else has changed with respect to PFML law? Well, there's an increase now on what both employers and employees have to kick into the fund. So employers with 25 or more employees, the contribution rate is going to kick up from 0.68% to 0.88% of eligible wages. This is going to be divided between employee payroll and wage withholdings. The next two bullet points here are, again, self-explanatory, up to 100% of family leave. That can be withheld from an employee's individual wages. That's going to figure out to be 0.18% of eligible wages. In addition, up to 40% of the medical leave contribution can be withheld from employees' wages. Here is a chart that I got from Mass.gov's website. I think it breaks it down. Obviously, same numbers here. Total contribution up top. You see in the next rung down, split between two buckets, medical contributions at 0.7%, family contribution at 0.18%. But most importantly, I think for what everybody needs to see is how that's going to break down in practice. 0.42% for the employer share on the medical side, 0.28% on the employee side, and on the family side, nothing for the employer and 0.18%. However, it's not exactly the same if your company has less than 25 employees. Again, most people are probably familiar with this, but it's less of a contribution rate at 0.46% if you have less than 25 people. Why? Because employers aren't required to pay the employer share of the medical leave contribution. That said, the small employers still need to be responsible for collecting and remitting the contributions on the employee wages, but they're not under an obligation to contribute themselves. So again, looking at this chart, how would that break down? 0.46% again with the two buckets, but you can see at the bottom line here, 0% from the employer on each side, and then the employee share being 0.28%, and the other employee share on family contribution being 0.18%. So I know this is a lot of numbers. Our recommendation here obviously is make sure your payroll software is up to date with these changes. Make sure you're working with your accountants. If you're doing this yourself, understand that these changes are going to take effect January 1st. So you have a little bit of time left, but you should be prepared to work with either your software solutions, your internal controllers or accountants to make sure that everything is up to date so that your withholdings are appropriate. One more change here, effective January 1st, the maximum weekly benefit is going to kick up to $1,149.90. That's approximately a $20 increase. So we can anticipate going forward in the next few years, this is going to continue to increase. Likewise on the contribution phase, and we'll deal with that as it comes. So we haven't received any questions yet from employees on this, but we are in the process of notifying them, and we'll roll out these changes. And again, it should be fairly seamless so long as everybody is prepared. I did want to take the opportunity to address one other issue here. I don't have slides on this, but it is something that I've discussed with the chamber before. It's something that continues to create issues, certainly for companies throughout the Commonwealth, and it specifically has to do with PFML. So many of you may be aware, but a person that returns from leave essentially has a type of job protection when they come back, so that if they're terminated for any reason within 6 months of their return from leave, the law actually presumes that the employer retaliated against the employee for taking that leave. From an employer standpoint, I can say that seems nonsensical and irrational when there may be completely legitimate, justifiable reasons. But it is an issue we have to deal with. Well, how does this work in practice? It's not a distinction without a difference, because instead of, in a normal case, you'd have an employee, if they believe that they were either discriminated against or they were wrongfully terminated, it would be up to the employee to prove that the employer, their company, did something wrong, did something illegal. Now, the law is going to presume that the employer screwed up. They're going to presume the company did something wrong. And it's up to the employer to prove their innocence. That may seem the same thing. It is not. From a strategic standpoint, from a negotiating standpoint, if you have pending claims, the employer is put in a somewhat vulnerable position because they're having to explain their actions in a way where it's not just a simple defense. So our recommendation here is to proceed very cautiously. The question we get asked the most is, can we terminate somebody within this 6-month window? The answer is yes, you absolutely can. Massachusetts is and continues to be an at-will state. So on paper, if you look this up online, if you read resources, if you speak to other professionals, they will tell you that anybody can be fired in Massachusetts for any reason, again, assuming that there are no contractual or union issues, but we're an at-will state, so you can be fired for any reason at any time with or without notice. That said, when you have this leave issue hanging out, when somebody has sought job protection under this, then you have to proceed very cautiously when you're terminating it. An issue that we see here and that comes up often is somebody has burned through their sick time, yet they continue to rack up attendance violations, and they would automatically be terminated based on our policies and procedures, but it's within this 6-month window. So what do? It's a legitimate termination. It's a legitimate company decision, but the law places this this excess burden on us. So it is something we're working through. I would love to have a rock solid recommendation for everybody here. I would just rely on your common sense and rely on the fact that you're going to make decisions that's best for your business. But when you do terminate somebody within that 6-month window, we basically designated here as sort of a more high risk termination because of this. You can still do it, but there is that extra burden to basically cross your T's and dot your I's. So really, those are your two options. Make sure your files are correct. Make sure that you're absolutely terminating an employee for a legitimate, predetermined reason. And if you're uncomfortable doing that, then the second best thing is to wait the 6-month window so that you don't have this rebuttable presumption that you're fighting against, because it's certainly going to be a costly endeavor. And when it comes to employment cases, when it comes to topics like retaliation, that's when you get into punitive damages and stuff that is, really scary for businesses and certainly for insurance companies that we all use. So I just wanted to leave everybody. I know I'm ending on such a rotten note, but it is something that I wanted to make sure that the Chamber's members understood, knew it was out there, and to say basically you're not alone. We're all trying to work through these issues, and happy to take any questions. But thanks again to Christina. She's our PFML guru, and really appreciate her time and effort here. And thanks everybody at the Chamber to give us an opportunity to run through these quick updates. I know this was a brief presentation, but we're happy to take any questions.
Great. We've got several questions in the chat.
Sure.
We'll kind of go from there. One of the questions is, would sick time be allowed to be used to top off, or does it have to be paid time off? Or because some companies make distinctions between those two. So how does that work?
Yes, sick time is included in PTO, sick time, vacation time. Here at Gold Medal, we also have it separated by sick time and vacation time. So
Yep.
whatever sick time the employee has accrued so far, they can use that to top off. Yes.
Another question, and this is one that several folks have asked us. If you have short-term disability offered to your employees, does any of that offset the PFML?
Yes, it offsets the benefit amount that they would be receiving, and we'd see that benefit amount in the notice of approval. But we don't have to worry about that with the top off because it has already offset the benefit amount, and then we'd be using that benefit amount to calculate the top off.
Okay, so the short-term disability would essentially take the lead, and then PFML would be paying the difference between up to their amount.
Yes. Yeah. When an employee applies for mass paid family leave, the employer does get a questionnaire to fill out, and it does ask the employer if the employee is receiving any other benefits, such as short-term disability benefits. So as long as we are accurate in our responses, then the mass paid family leave will take our information and then calculate their mass paid family leave benefit based on our information.
And in your experience, kind of a follow-up to that, is it with paid family medical leave now, is short-term disability kind of a redundant benefit? Is it something you don't need to have?
That's up to you. We did have here at Gold Medal, we did have a short-term disability benefit that we did get rid of when the mass paid family leave kicked in, because we knew that the 80% was going to be a higher amount than the short-term disability that was offered to them. So it really depends on how generous your short-term disability benefit is. If
Yep.
it is paying at 100%, then the employee would still be entitled to 20% of that benefit. But if it's anything less than 80%, then it is more of a redundancy than anything else. Yeah.
Thank you. Let's assume that an employee takes PFML and is out the full 20 weeks for his or her own serious illness. During that time, the employer hired another employee to serve in the same capacity as that employee on leave. At the end of the employee's PFML, the employee obviously, as we've discussed, has the right to return, and the employer does not need two employees in that capacity. So does the employer have to terminate the new employee due to the retaliation provision? We're assuming the answer is yes, but any other suggestions? What if the new employee, frankly, is much better?
Yeah, this
Well-
this is a great law school exam question. Certainly, but that said, it really hits home for us. That's a real life situation. I would say this: the person on PFML leave absolutely has job protection. So replacing them with a new person as they come back would be highly frowned upon, and you would be exposing your company to excess liability. I would recommend, if you're getting a temporary person in there, to be very clear with your job descriptions and job hiring that it is a temporary position for perhaps even an undetermined period of time, or a very finite period of time, so that you're also honest with that person as well. That would be my main recommendation. If the other person, the new temp, is better, I would say that, you'd have to evaluate your company's needs to determine whether or not that person can be put in another role and whether or not you can bide your time. But if it's a PFML person that is returning, they're going to have that job protection, and any termination that you do, especially if it's to replace them, you're going to be exposing your company to some real problems.
Thank you. Thank you very much. There was a question regarding the ability to access the slides after the presentation. You may have missed it, but at the beginning, we are recording this. You'll be able to get the entire thing on YouTube, and we'll be sending it out to all who registered. A question from Gerald: are any of the payments available retroactively for COVID-related leaves, like the federal FFCRA?
I'm not sure I understand the question.
Gerald, would you like to unmute yourself and clarify your question?
Yes, thanks, Rick. There is a federal program for COVID-related leaves that were family-related that is still available for employees to retroactively get payments. And I'm wondering if there's anything like that in the state program.
Well, the only thing I've seen on that is if the employee filed a claim after November 1st, but it was for a leave that started before November 1st, then yes, they can get the top off. That's in relation to the top off amount. But that is the only retroactive information I've seen in my research so far for this presentation. So I apologize. I don't know the answer to that one.
Okay. Well, thank you. I'll perhaps send on some information I have about the federal program that might be of interest to you guys.
Thank you.
Okay, thank you.
Question: how do we determine the number of employees? Is it literally 25 employees at any time of the year, or is there a formula to determine this? There may be some that are seasonal, for example, that may have 10 employees during the winter and 30 employees during the summer. So how is that calculation made?
Yeah, that's a great question. I think it's when the individuals are hired on and they're actually having their deductions made, it's the employee count at the time. That said, mass.gov may have some additional guidance on that, but that's my understanding of it. It's you're setting your calculations at the employee rate at the time that these people are there. With with seasonal and part-time employees, I'm sure there's some fluctuations, but I don't know the nuances of those calculations.
Thank you. Kurt Nelson, I saw that your hand was up earlier. Is there a question that you might have?
Yeah, well, just a comment. I do have had a couple of claims with small groups that have short-term disability. And generally speaking, the insurance companies look to government-funded programs as primary and insurance is secondary. In the case, the few claims I've seen, PFML was the primary replacement of the employees' lost wages, and the short term made up the difference. Especially after 20 weeks, when PFML medical side has the maximum benefit period. And generally speaking, most short-term disability policies can go up to 26 weeks. So I've seen some employers keep their short-term because of that 6-week gap in benefits to bridge to a long-term disability policy. It still boggles the mind as to why the state just didn't do a 26-week benefit. But getting back to the discussion about employee size, this is something I think we need to dive into as a chamber. You can have employers that hover in and out of 25, 23, especially in this employment market. You can hire 3 people in 2 weeks, they could be gone. You could go from 22 to 25 employees in 3 weeks and be back down to under 25. I wonder, when you reapply every year, is that maybe when the day you go by? December 31st, how many employees I have is what I'm going to do, whether I'm going to be a large or small employer for the next 12 months.
How you calculate your fiscal year, like I said, and there is nuance there. You're absolutely right. I don't have the answer there. I think what your employee count when you're doing these calculations obviously matters, but when you do them may vary. So it's a great question.
I wonder if we can get clarification, Rick, from the state. And
I place this firmly on Ian Trombley's shoulders.
Yeah, absolutely, Kurt. It's a great point, and it's a good segue. I was going to kind of bring this up to the group. There are some unintended consequences to this law, of course. One being that right there, kind of confusion, nuances. Another, a growing trend amongst employers is unlimited vacation time, because there's some evidence that suggests that if you offer unlimited vacation time, employees will actually use less than they would if they had a specific amount of time. So what happens then? If you have unlimited time, of course, you'll use up all unlimited, the whole time to top off your entire leave. So what are employers who offer that benefit supposed to do? That's unrealistic because there is no downstream impacts, as Matt suggested. So I wanted to
for the record, we're not one of those employers.
No, we're not. Thanks for the reminder, Rick. So,
is there such an employer?
Are there any other unintended consequences like that we can take, that similar to like Kurt brought up, that we can go back to DFML to, explain some of these issues? That are there any other things like that they might not have expected or seen? Because we will absolutely be doing some follow-up on this.
Yeah, I think it would be good to educate our members of the importance of having employment practice liability, because this is just added a whole new set of lawsuits that employers can be looking at. An employer should have employment practices liability anyway, but this just exacerbates the issue that employers can be looking at.
Well, right, and I think you're absolutely right, because what this does is there are some counterintuitive concepts in these, both in wage calculations and PFML leaves and top offs. So yeah, can't stress that. Make sure you have a good relationship with your broker and all your premiums are up to date, because you know, it certainly comes in handy.
A question surfaced about whether there are any efforts, whether there's any legislation at all that could potentially curtail the retaliation provisions.
Not that I've seen.
I have heard of none, Gary, but
yeah, no, I actually, I just, you know, this is obviously this issue has reared its head multiple times in my year tenure, which admittedly is not very long. So I've reached out to multiple colleagues, both within the industry, in the Commonwealth, as well as employment practice lawyers, litigators. Everybody is advising their clients in a similar fashion, and that is tread very, very, very carefully. Some will go out, you know, and just have a full stop prohibition on termination within that 6 months. I tend to not go that far, because I still think the statistical likelihood that somebody will file a claim, assuming it is a legitimate termination, is still lower than an absolute. So, but that said, I can't discount the risk. And as I'm advising Gold Medal, as I'm working with outside counsel, it is a real risk, and none of us quite know how it's going to play out.
well, on that happy and cheerful note, I think we have, I think we've actually gotten to the end of our questions. Matt, Christina, thank you so very, very much. This is extremely informative. I can say with a degree of certainty, as I approach retirement in 2 weeks, I'm glad I'm not going to be an employer any longer. It seems like every year there is some level of complication that makes being an employer a challenge. So we completely understand, but thank you very, very much for your insight, the clarity of your presentation. Ian, thank you for helping to put this together. Katie, thank you as always, and other members of the team.
Thanks, everybody. Best of luck, Rick, on your retirement. Thank you, Ian, Katie, and everyone at the Chamber. We certainly enjoyed this. And if anybody has any additional questions that they want to you know, work through the Chamber to get to us directly, we're happy to try to follow up on any issues that arise.
Thank you. And once again, this will be available to all who signed up for the seminar today. You'll be getting a link to our YouTube channel where this will be available, but feel free to follow up with questions that we can pass along.
Thank you.